Welcome. I'm Angela Campbell, and I am a professor at the Faculty of Law at McGill and member of the Center for Human Rights and Legal Pluralism. I'm also the Associate Provost for Equity and Academic Policies at McGill. So I get to spend less time at the faculty these days than usual. And then I would like, to be honest. But I'm delighted to be back here virtually today to facilitate this discussion that I'm looking forward to very, very much, led by Daniel Del Gobbo. So it's going to be my pleasure to introduce Daniel in just a second. And he'll lead us through a talk that will be probably about 20 to 30 minutes. And then we'll open it up to some Q&A. And this is a really important topic, both to me in terms of being a researcher, but also in my work in connection with McGill University. In that role, I've overseen the development of our own university's policy against sexual violence and seen the real challenges of trying to put forward a survivor-centered approach in both the administrative context that we work in a university, but also legally when we think about specialized courts for sexual assault and sexual violence crimes. So I'm really looking forward to hearing Daniel's insights in this regard today. So I'll introduce Daniel now and in advance thank him for his presentation and say that he is a Banting postdoctoral fellow here at McGill's Faculty of Law. And his research focuses on the possibilities of restorative justice and transformative justice in promoting equality for women, LGBTQ2+ peoples, and other historically marginalized groups. Daniel earned his SJD from the University of Toronto's Faculty of Law in 2021, where he was a Trudeau Scholar, a Shirk Doctoral Fellow, and a Viscount Bennett Fellow. Previously, he earned his LLM from Harvard Law School in 2015 and his JD at Osgoode Hall Law School in 2011. He's published widely in the areas of civil procedure, human rights, access to justice, and feminist and queer legal theory. And he served previously as an adjunct professor at Osgoode Hall Law School between 2015 and 2019, where he taught 2 courses in ADR and restorative justice and received several awards for teaching excellence. So he has a book on which today's talk is based, and it's entitled Negotiating Feminism, Charting a Path Through Law, Sex, and Violence, which is forthcoming in U of T Press, and I'm really looking forward to that. So with that, I'm going to hand it over to Daniel to hear him, and I would invite everyone to just listen for this period of the talk, and then very, very gladly to take your questions, either by raising your virtual hand or entering in the chat once Daniel has had a chance to share his important work with us. So Daniel, over to you.
Thank you so much, Professor Campbell, for that introduction, and to Sharon and everyone for organizing this event. I'll just share my screen. I have a few slides, so bear with me for a moment. Okay, everyone should be able to see that, I hope. Great, one moment. Great, so thank you very much for having me again. I'm honored to be speaking with you from Toronto, which is located on the treaty lands and the territory of the Mississaugas of the Credit First Nation and the traditional territory of the Anishinaabe, the Wendat, and the Haudenosaunee. The meeting place of Toronto is home to many Indigenous peoples from across Turtle Island, and I'm extremely grateful to live and work as a guest on this land and to partner with organizations like the Center for Human Rights and Legal Pluralism that advocate for the rights of Indigenous peoples. So my presentation today is called Negotiating Feminism, Campus Sexual Violence and the Possibilities of Informal Justice. The research builds on my forthcoming book, as Professor said, also called Negotiating Feminism. Other content in the presentation is based on my recent publication called Feminism in Conversation, which was published in the UBC Law Review in 2021, as well as my current postdoc research at the McGill Faculty of Law. So before launching into it, I thought that I would talk about my research agenda briefly to situate my presentation in context. My research falls at the intersections of civil procedure, access to justice, human rights, and critical theory, including feminist and queer theory. And I emphasize critical theory because my research is motivated by my impression that the civil procedure and access to justice fields have been critically under-theorized. One reason for this is that historically the problem of access to justice in Canada has been framed in a manner that equates access to justice with access to the courts. It is a formalist conception, without having regard to whether the forms of justice being accessed in this conception are worth accessing in the first place, without having regard to how the parties to legal disputes experience the court system, or to whether the purported neutrality of legal rules and procedures may be contributing to racial and gender subordination and other systems of oppression. So keeping these issues front of mind, my research is focused on the potential of civil procedure and ADR, restorative justice and transformative justice to increase access to justice, which I frame as having both procedural and substantive components. I'm interested in exploring how power and resources are distributed through legal processes and recommending how law can foster the conditions that women and LGBTQ peoples and other historically marginalized groups need to flourish. My presentation today reflects these commitments. Campus sexual violence has become the province of increased rulemaking, governance, and bureaucratic activity in the last 10 years. Feminist law and policymakers have campaigned for targeted reforms in these areas, including the widespread adoption of campus sexual violence policies at colleges and universities across Canada and the United States. One of the byproducts of this strategy to incorporate feminist values into the state and the state-affiliated power of colleges and universities has been the creation of new institutional arrangements that address campus sexual violence through liberal legal methods. On their face, most policies reflect the preference that students report their experiences and make formal complaints in campus adjudication as their primary means of legal and political redress. Consistent with these trends, feminist critics have argued that consensual dispute resolution can lead to unfair procedures and unjust results in campus sexual violence cases. And this view is widely supported across Canada and the United States, causing many colleges and universities to limit or ban the use of consensual dispute resolution in their policies altogether. Notably, the US Department of Education's Office for Civil Rights released an influential guidance in April 2011, known as the Dear Colleague Letter, which prohibited the use of mediation in campus sexual violence cases under Title IX, a US law that requires gender equity in federally funded education programs. Mediation is the only consensual process named in this guidance. However, most colleges and universities interpreted the guidance to prohibit the use of restorative justice as well. In my remarks today, I provide a critical feminist perspective on the role of consensual dispute resolution in campus sexual violence policy. I'll argue that the progress of campus sexual violence reform has evolved to reflect what I call the ideology of legal centralism. Taking sexual abuse seriously by privileging the formal law and campus adjudication over other systems of justice. Crucially, and this is where I extend the arguments of my predecessors, the ideology of legal centralism has entailed a corresponding skepticism, if not a categorical rejection in some cases, of consensual dispute resolution for challenging this methodology. And I believe this is a mistake. As such, one of the purposes of my talk is to recalibrate feminism's relationship with informal justice. It's an internal critique of centralist trends in feminism from within feminism itself. So I'll structure my remarks as follows. First, I'll begin by recounting the facts of a recent case study, the Dalhousie dentistry case, explaining the male student's conduct in the case and the restorative justice process that followed. I recount the facts because it's important for us to recognize the gravity of the harms that the students experienced, but please be advised that the case involves sexual assault, so please take care when listening to this part. Next, I will summarize 2 lines of feminist argument that the restorative justice process in the case and consensual dispute resolution generally fails to take sexual abuse seriously, what I call the power imbalance critique and the social change critique. And this brings me to the crux of my argument in the talk. I will show that feminist concerns about consensual dispute resolution are partially explicable by feminism's embrace of legal centralism and specifically carceral thinking in contemporary modalities of feminist anti-rape activism. And I conclude the talk by exploring the potential of consensual dispute resolution to bring about important benefits so long as every process is conducted responsibly in a manner that promotes substantive equality. Realizing this potential is only the starting point of a strategy, I suggest, but it leaves us with challenging questions about how we might broaden our focus from legal processes to institutions and transform colleges and universities themselves into sites of radical structural change. So on December 6th, 2014, a fourth-year male student in the Faculty of Dentistry at Dalhousie University posed a question about his female classmates in an all-male private Facebook group of students. The question took the form of an online poll asking, "Who would you hate fuck?" and provided names to vote on. Shortly thereafter, screenshots of the online poll and other offensive misogynistic posts were leaked to the CBC News, where the story exploded in the media and the full scope of the male students' conduct came to light. Most troublingly, several of the men talked about committing sexual assault. One member posted a photograph of a woman wearing a bikini and wrote the caption, "Bang until stress is relieved or unconscious." Other members commented on the photo asking, "Can you tell me what chloroform smells like?" Most of the female students involved chose to proceed with their complaints through a restorative justice process on campus. The women's rationale for choosing restorative justice was that a more collaborative approach would create a safe and confidential environment for the students to critically reflect on their experiences and find ways to improve the academic climate and culture at the faculty. The process ran for 5 months, with each of the male students spending over 150 hours in restorative justice. And feminist critics were extremely vocal about the perceived weakness of the process at the time. Isabelle Cote wrote in the Huffington Post that restorative justice was a depiction of rape culture that required a more punitive response. Feminist student activists rallied at the university to raise public awareness of the issues, holding signs that read such things as "Expel misogyny," "We want names," and "Expel rape culture." An online petition that the university should punish the male students garnered over 50,000 signatures. The Halifax police became involved in response to requests for a criminal investigation, pleading for the female students to come forward and make formal reports. Feminist scholar Constance Backhouse led an external task force that was charged with investigating the events that transpired on campus. And the task force's report celebrated parts of the restorative justice process and criticized others, calling it an innovative educational and rehabilitation initiative, but ultimately finding that it had procedural deficiencies and should have been conducted in a more publicly accountable and inclusive manner. The report states that "swept under the rug" was a phrase heard over and over again. The report concludes, "The best route for the future is to focus on systemic change." Feminist concerns about the restorative justice process can be roughly organized around two main themes: power imbalance and social change, which are closely interrelated. I'll outline these concerns briefly, many of which are legitimate, to provide context for my arguments that follow. The power imbalance critique is that complainants might feel pressure to choose consensual dispute resolution in conditions of gendered power imbalance. Campus sexual violence occurs in a context of systemic gender inequality in our society. Consent to settlement, not unlike consent to sex, routinely coexists with elements of force, fraud, and coercion, which complicate the liberal notion of free and unencumbered choice. This inequality is animated by the intersection of race, class, ability, sexual orientation, gender identity, and other systems of oppression. The risks of gendered power imbalance are exacerbated by the fact that consensual dispute resolution is less rigidly structured than campus adjudication. Privacy and confidentiality rules mean that consensual processes can fall outside the reach of public scrutiny and render complainants vulnerable to harm and exploitation. Arguably, the cultural expectation that complainants should forgive their abusers and participate in these processes is a gendered script that allows campus sexual violence to continue. The social change critique is that consensual dispute resolution lacks the ability to transform the conditions that foster gender inequality because it privatizes and decriminalizes campus sexual violence. Privacy and confidentiality rules, while superficially respectful and empowering of women's freedom to choose, function simultaneously to elide the structural nature of the issues at stake. According to this critique, consensual dispute resolution works by narrowing and isolating the terms of political inquiry, framing cases as mere interpersonal disputes to relieve colleges and universities of their responsibility to think more systemically and to keep victims safe from harm. Campus adjudication, by contrast, has the important effects of assigning liability and guilt to perpetrators and preventing future violence by the expressive impacts that punishment has in our society. On this theory, campus adjudication recognizes that campus sexual violence contributes to a hostile environment for women, respecting the seriousness of the violation and the necessity of focusing on community safety. So generalized versions of these arguments have been rehearsed in legal scholarship for many years. Critics like Richard Abel, Owen Fiss, and Trina Grillo have argued that consensual dispute resolution inhibits social change by persuading individuals with legitimate grievances to sacrifice public accountability and transparency in the name of private peace. Grillo suggests that mediation gives rise to process dangers for women in family law cases because it curtails the competitive rights-claiming process and minimizes the structural aspects of a broader political struggle between women and men. As I understand it, this argument restates one of the primary justifications for liberal legalism, and by extension, the formalist conception that equates access to justice with access to the courts. On this theory, rights claims are the vanguard of the rule of law, which the state is obligated to enforce in the wake of neoliberal pressure to replace courts and tribunals with self-interested market actors who might settle for something less than what the law requires. In my view, there are at least three interrelated assumptions that underpin this line of thinking. The first assumption is that substantive justice is a concept inseparable from the law, and specifically from formal law, such that some feminist law and policymakers have argued that there can be no substantive justice outside the formal justice system and campus adjudication in particular. The second assumption is that fidelity to the rules laid down by our formal institutions is the highest ethical virtue, such that some feminists have claimed that additional or alternative rules established with the party's consent are a poor guarantor of substantive justice. The third assumption is that formal justice is an optimal means of achieving substantive justice in most, if not all, cases. So contrary to popular wisdom, I would argue that all of these beliefs are false. And this is a provocative claim because the liberal doxa of more law and more rights are pervasive in feminist culture, but this ideology misses a critical insight. So legal pluralists have long recognized that there appears to be a decline in the state's power to regulate our conduct through courts and policing. Correspondingly, legal pluralists have mapped the rise of other kinds of regulation in the state's place, transnational bodies, non-binding principles, and consensual dispute resolution among them. Communities of practice where the reach of the formal law cannot go, or where the reach of the formal law can go, but there's a mix of formal and informal practices underway. One of the implications from this work is a caution against the ideology of legal centralism, or the notion that using formal rules is the most effective way to provide access to justice in all cases. So in a classic work, feminist scholar Carol Smart makes a similar point about the criminal law of sexual assault. In accepting law's terms in order to challenge law, she writes, feminism always concedes too much. Feminists should challenge the creeping hegemony of the legal order in cases where extra-legal orders and community-based norms and structures have an important role to play. In my view, it follows from Smart's work that feminist law and policymakers should strive for more than simply intervening in political life vertically from the top down, how to prosecute a complaint, how to revise a policy, but thinking about the relationality of normative orders by restructuring relationships between people, by addressing the interface between formal and informal rules on a more horizontal level. The problem of campus sexual violence is infinitely more complex than what is suggested by the centralist myth that gives priority to formal complaints as the best or only option. And yet, on their face, many campus sexual violence policies follow the same basic structure. Complainants can choose how their reports will be processed, but choices are often limited to whether complaints will trigger a criminal process, campus adjudication, or no response at all. Most policies encourage complainants to report their experiences to campus security. Some policies provide that complainants have participatory rights in campus adjudication, but complainant involvement in the process is relatively limited. Complainants are free to stop engaging with campus adjudication at any time, but most policies establish the school's right to proceed with an investigation or hearing without the complainant's consent. Correspondingly, few of the policies create opportunities for the parties to engage in relational dialogue or community-based norm clarification around campus sexual violence. Provisions on consensual dispute resolution, where they exist, are either brief and unelaborated or significantly limited in their availability to students. There are parallels to the criminal law here, specifically the police or the prosecutor's sole right, depending on the province, to proceed with laying charges. And like in a criminal proceeding, there is little opportunity for complainants to tell their story in their own words, let alone retain any power over the consequences that parties should face. Make no mistake, campus sexual violence policies are civil in nature. The cases involve private parties, and the procedures apply to conduct that may or may not be independently prosecutable as crimes. Nevertheless, I would argue that the structure of campus sexual violence policies reflects the influence of what feminist scholar Elizabeth Bernstein has called carceral feminism, building on the work of critical race feminists and prison abolitionists before her. The term captures feminism's complicity with the reactionary politics of crime control, blurring social justice and criminal justice, punishing in the name of gender equality. Carceral feminism is predicated on the commission of reciprocal acts of carceral state violence against individual bad apples. In many cases, it functions like a neoliberal publicity stunt. Colleges and universities cleanse themselves of financial and reputational risk by exacting swift and harsh punishments on targeted people, most often Black, Indigenous, and LGBTQ students who are disproportionately targeted by this kind of discipline, in an effort to return the community to its previously safe condition, while in fact the problem has been individualized and broader systemic issues of climate and culture have been left unaddressed. So there's a growing body of literature on the harms of carceral state violence, but its relation to consensual dispute resolution has been relatively unexplored. I would argue that the feminist ideology of legal centralism, and carceral feminism specifically, has entailed a corresponding skepticism of consensual dispute resolution because it challenges this ideology. One of the co-facilitators of the restorative justice process in the Dalhousie dentistry case, Jennifer Llewellyn, suggests that, quote, the certainty offered by formal systems resulted in considerable disappointment, occasionally rising to the level of outrage that restorative justice had denied what was deserved or owed according to existing formal processes. So recall that feminist student activists lined the streets to publicly condemn the male students' conduct, holding signs that read, "Expel misogyny" and "Expel rape culture." Consistent with this view, feminist critics of the process petitioned the university to conduct a more punitive process on a parallel track. The political resonance of these calls for punishment is inextricably bound up in the conception of the so-called perfect victim of campus sexual violence, emphasizing the vulnerability of white, class-privileged, heterosexual, and cisgender women who are presumed to be injured and therefore most in need of the state's protection. Llewellyn comments on the influence of carceral thinking in the case. Quote, the public demanded that the university play its traditional part in the justice story. They were to find the monsters and punish them, ideally by isolating them from the rest of us, by expelling them from society, and somehow making us all richer for their loss. Arguably, the certainty of punishment was so ingrained in the case that it affected an epistemic occupation with formal law, causing some people to experience profound difficulty conceptualizing the prevention of sexual violence without recourse to the state. So to be clear, I'm not suggesting that the restorative justice process in the case was conducted without fault. As I explained previously, the task force's report raised serious concerns about the process at the time. I'd be pleased to elaborate on the case in the Q&A portion if colleagues are interested. And I'm also not suggesting that colleges and universities should get out of the business of campus adjudication altogether. I recognize that suspensions and expulsions are necessary responses to campus sexual violence in some cases. Rather, I'm making a more nuanced point about what legal centralism misses. I think it should be incumbent on feminist law and policymakers to critically reflect on the terms of our strategic organization. It means asking, what is being lost by some feminists' perceived strategic necessity to incorporate our political values into the state and state-affiliated power of colleges and universities? Correspondingly, what might feminists have to gain by engaging with alternative modes of legal and political formation, including the processes of informal justice that have not been traditionally regarded as transformative, so long as those processes could be conducted in a manner that promotes substantive equality. In my view, colleges and universities should provide for both campus adjudication and consensual dispute resolution in their policies, with a view to increasing student participation and empowerment throughout. Colleges and universities should provide what are known as loop-back mechanisms in their policies, which allow complainants to move between formal and informal options in a hybrid fashion, as the facts of a case dictate. On a parallel track, colleges and universities should be proactive in changing structural features of the learning environment that contribute to campus sexual violence, recognizing that complainants should not bear the heavy burden of triggering policies and addressing campus sexual violence on their own. Campus-wide initiatives to transform the learning environment should be adequately funded and staffed and supported by the government in order to meet this objective. So in my remaining time, I will explain that consensual dispute resolution can bring important benefits that cannot be easily replicated by campus adjudication. Certain of these benefits are derived from the consensual process of mediation and restorative justice, what I call the process advantage, while certain of these benefits are derived from the outcomes or remedies of the process, what I call the outcomes advantage. So first, there's the process advantage. Consensual dispute resolution works by redirecting the parties' attitudes toward one another. In this way, it's capable of fostering increased party self-determination and greater understanding and respect between the parties. Empirical research confirms that complainants experience emotional and psychological benefits from increased participation, empowerment, and choice in mediation and restorative justice. Form mirrors content here. I recommend that colleges and universities should pre-screen cases to identify gendered power imbalances and determine the procedural safeguards that are necessary to practice consensual dispute resolution safely and effectively. This recommendation is consistent with legislative advancements in Canadian family law that require screening for power imbalances before mediation can be used to resolve cases where there is a history of family violence. Once this screening protocol is complete, mediators and facilitators should work with complainants and respondents to implement a process that addresses the specific dynamics of the relationship and enables the parties to make fully informed decisions about their own well-being. And this is a proactive and ongoing responsibility. Mediators and facilitators should provide complainants with the information and resources needed to ensure a well-functioning process. They should feel ethically empowered to intervene in parties' discussions, to correct abusive statements, prevent face-to-face communication, and terminate the process as needed. Conventional ethical requirements of mediator objectivity and neutrality should not serve as a barrier. Complainants with a history of trauma symptoms should be observed particularly closely, keeping principles of trauma-informed lawyering in mind. Second, there is the outcomes advantage. Consensual dispute resolution can be practiced in ways that remediate campus sexual violence as a systemic problem. Complainants can table a broad range of remedies in consensual dispute resolution, including public apologies, educational initiatives, and community engagement. Another benefit of consensual dispute resolution is that it provides an opportunity to collaborate with feminist organizations that bring years of experience in combating campus sexual violence, but would lack the standing to participate otherwise. Notably, the restorative justice process in the Dalhousie dentistry case culminated in a day of learning event in which complainants and respondents and representatives from over 80 community groups came together to brainstorm ways to improve the academic climate and culture at the university. So previously, I explained that consensual dispute resolution has been criticized for privatizing campus sexual violence. On the one hand, privacy and confidentiality rules are vital to creating a campus environment in which complainants feel comfortable reporting their experiences and obtaining social supports while protecting their identities. Confidentiality reduces the risk of publicity and gendered community backlash that can follow from public reports. The challenge for colleges and universities then is creating a policy framework that realizes the benefits of confidentiality, but without minimizing the structural aspects of campus sexual violence. To this end, I recommend that colleges and universities should publish anonymized data about the facts of complaints, the kinds of processes used, and the outcomes reached in both campus adjudication and consensual dispute resolution on an annual basis. Given its focus on community involvement, restorative justice may be particularly effective at changing features of the campus environment that empirical research has shown to contribute to campus sexual violence, including cultural belief systems, levels of peer support among men, and corollary behaviors like drinking and drug use. To realize this potential, restorative justice should aspire to the values that critical race feminists and prison abolitionists refer to as transformative justice. That is, it should focus on the links between interpersonal violence and structural violence, cognizant of the role of the state and civil society institutions in producing racial and gender subordination. So restorative justice and transformative justice reflect the same relational values of collaboration and informalism in their practice. However, transformative justice arises from the experiences of collectives of women of color as a means of conjuring up alternative community-based relational orders outside the reaches of the state in some cases. One of the key lessons from this work is that the purpose of restorative justice cannot be to merely restore the parties to an oppressive status quo, but create new and more equitable relations for the future. If campus sexual violence is facilitated by conditions of white supremacy and male dominance, then white supremacy and male dominance, as they are taught and reinforced by the state, must be challenged as well. Realizing the potential of consensual dispute resolution is only the starting point of a strategy, but I believe it illustrates that taking a more comprehensive approach to campus sexual violence requires a paradigm shift in the terms of feminist law and policy making to date. So I'd be pleased to elaborate on my policy recommendations in the Q&A portion as well, but for now I'll conclude with a brief reflection on the implications of my critique, which is based in feminism, but I would argue is generalizable to other fields of legal theory and activism. It strikes me that in legal institutions steeped in carceral thinking, policy formations that challenge the ideology of legal centralism, and more broadly, the formalist conception that equates access to justice with access to the courts, are frequently read as an external threat to the politics in question, as being soft on crime or a form of weak justice, and therefore outside the bounds of effective action, a move which has prevented law and policymakers from engaging with them. It raises challenging questions about positionality and embeddedness, specifically the constraints on our perspectives on what counts as feminist in the campus sexual violence context, or as progressive and redeeming and transformative in other contexts. The challenge of practicing law in the radical mode is that it resists the circumscription of prevailing legal methods, and that it invites, if not demands, lawyers to reimagine how they conceptualize what access to justice means. As I explained earlier, critical race feminists have argued for the use of relational community-based alternatives to the formal law, as well as a corresponding reduction, if not full-scale elimination, of punitive sanctions and carceral state institutions across the board. So it's effectively to ask, can lawyers contribute meaningfully to radical social movements for change, reaching outside the limits of the formal law and other legal institutions in which they are embedded to fashion a world in which substantive equality exists? So one of the purposes of my postdoc research here at McGill is to investigate these very issues, to explore the similarities and differences between restorative justice and transformative justice in the human rights context, to think about whether transformative justice, as it is theorized and practiced outside the reaches of the state, is even translatable in legal terms. And I cannot pretend to know the answers to these questions with any certainty, but I've seen that colleges and universities are laboratories of critical thinking and innovation. Incredibly important work has been done at McGill and elsewhere to try to decolonize the law school and university more broadly, decentering the formal law and foregrounding the role of human agency and local community-based knowledge and indigenous practices to restructure colleges and universities for the better. I suspect that consensual dispute resolution and its theorization as a site of radical institutional change, both on campus and beyond, is needed now more than ever. So I will stop there, but thank you very much to the CHRLP for organizing this talk and providing an opportunity to present my work. And I'd be pleased to continue the conversation and answer any questions that colleagues might have. So thank you very much again.
That's great. Thank you so much, Daniel. So we've got a nice slot of time for discussion, and I have a range of questions, and could talk to Daniel for the whole afternoon, but I don't want to selfishly to kind of use too much of the floor. So what I'm going to do is I'm going to open it up to anyone in the audience who wants to ask a question or offer a comment. And please feel free to just raise your virtual hand or to put it in the chat. So Penelope.
First of all, thank you so much for this presentation. It's been super interesting, and it's the subject of sexual violence is something that I'm really interested in, and how we kind of like solve these like resolution issues. And I was wondering what you thought of the new project in Quebec on a specialized tribunal on sexual violence. Do you think this will bring like meaningful change on sexual violence reform, or is this not effective and it doesn't really actually change the status quo? So yeah, just wondering what you thought of.
Thank you very much for the question. So I'll confess to not being an expert in current developments in Quebec, but from my knowledge generally of specialized tribunals that address sexual violence, I think that they really pose a lot of opportunity, just because this is an area of law that is highly specialized, in which it's been very well documented that lawyers and judges consistently make mistakes, confusing basic principles of the twin myths as they apply to sexual assault law, failures to understand what a trauma-informed practice is and how experiences of trauma can often lead complainants and victims to respond to questions and interviews and cross-examination in ways that might not be readily understood or expected, and to remember things not always as clearly as other legal actors would expect them to. So I think that building expertise within law that is focused in this area, and having legal decision makers who are held account in that way, I think is generally a very positive development. So I look forward to seeing how the initiative is built in Quebec, and hopefully the positive results that will come from it.
Thank you. I might, if I can, jump in then if I'm not, and please feel free to raise your hand as we go. But I guess one of the things that I find really interesting listening to the paper is thinking about how I'm so with you in theory, right? So I'm with you along the way, like 100%. But then based on my experience working with survivors and their advocates and groups that represent and support survivors, the discourse is so different. It is so firmly anchored to a legal centrist position. And the couple of things on that is, like, first of all, when I first was in my role in the administration of McGill, and student activists came to me and said, we need a university policy on sexual violence. And that really struck me as interesting, because I'd kind of grown up as a jurist at McGill, where legal pluralism really was the name of the game. And you were really encouraged to not think about formal rules as necessarily the drivers of how behaviors change, and also as real sites of authority and resistance. But in those discussions with these young people who are really passionate, and some of them had been hurt to the point of trauma, they didn't care about legal pluralism. It was a very monist view of where authority comes from, which is institutional power. And the view from that site was that you need a policy to say what's important to you. And a word that was sewn in over and over that actually didn't come up in your presentation was accountability. So the only way to hold people accountable was to have things firmly written down in a policy that is anchored to the institution and that requires scrutiny to change. And it doesn't depend on who's in charge in a given moment. So it's just really interesting because I came at this kind of very wicked problem from a position of legal pluralism, and then quickly was schooled by people who were doing the work in the trenches to say, what matters to us is a formal written policy. And if you go down the route of mediation and restorative justice, that was not viewed as a feminist position at all. It was viewed as a very, very clever way, maybe not so clever, for the institution to make quiet deals in closed quarters where there would be no transparency, visibility, or accountability. So it really was a tough set of discussions. In our policy, mediation is built in, and we do have a screening process, kind of like what you described. But one of the big questions there was like, who's doing the screening? So why can't the survivor be the one to decide whether or not the case is appropriate for mediation or not? And anyway, it was just like, it's not really a question, but it's more just a presentation of, how I thought about this issue from the perspective of an academic, to then moving to an administrative position where I was confronted with people who felt, especially people who didn't have a training in law, who felt like, no, the law is where power resides. Formal law, formal rules. And if you don't anchor yourself to formal rules and it's just like, cultural norms, then it's super ephemeral and elusive, and we have no way to hold people to account. And then the other thing I'll say is that the approach of the bad apples, right, where you kind of figure out who the bad actor is and you hit the eject button, that's very popular. And that's really viewed as a site of like redress, because it's faster and easier to measure than the long, hard toil of institutional change. So anyhow, those are just some observations, but be really love to hear what your thoughts are on all that.
Thank you for that, Professor. It strikes me, I was frankly making notes as you were chatting because there were so many points that I wanted to address. I do have the sense that we could probably talk about this for a long time. So I'll just try to answer bits and pieces of what you said to the best of my ability. If I missed anything or you have any follow-up questions, please feel free to jump in. So you raise a really important point that formal legal recognition matters to many survivors, right? Like, as you say, the discourse was anchored in a legal centralist position. Many student activists who were representing survivors really saw the institution of a policy and a finding of responsibility, perhaps leading to, whether it's a no contact order or a suspension or an expulsion in serious cases, as justice, right? And that's a valid position, something that I really want to underscore, that complainants' interests in these cases, survivors' interests, are incredibly varied. And I would never want to suggest that consensual dispute resolution is a solution, an optimal solution for everyone, because it isn't. I was sort of getting at this when I talked about how mediators and facilitators need to exercise their discretion in cases to terminate a process, if there's an acute risk of harm, but also just as a precondition for participating in any of these processes, survivors need to consent. It's by law, in policy, they need to choose this process. In restorative justice in particular, many restorative justice facilitators would say that, in fact, respondents, or responsible people, as they're often called in the literature, need to admit responsibility before the process can proceed, right? So there's a series of conditions that need to be met. So I just want to sort of point that out. And what I'm trying to do in this work is emphasize the importance of providing options, a range of options. In a complainant-centered or survivor-centered process, they should be the ones that ultimately choose the process that follows from their disclosures or reports. Obviously, complainants may disclose sexual violence to a school and not wish there to be a formal process that follows, or they may file a report. And then I believe that they should be presented with options, both formal and informal, and opportunities and pathways for them to shift between formal and informal options as the facts of the case may dictate or their interests may require. Another interesting point that you raised was about accountability. And I think what I am trying to do in the work is push back against this legal centralist notion, this carceral feminist notion, I suggest, that accountability is equated with punishment. Again, for some people, that may be the case. But I think for many others, and empirical research on restorative justice processes now confirms this, that accountability is derived in relationships often. It's in people's relationships, not only with people that harmed them, but with the community members that perhaps enabled the people who harmed them. That if those relationships can be improved through the processes that we implement, that is a form of accountability that is worth recognizing and making room for. So again, what I'm trying to do by thinking about these issues in a pluralistic way and the providing of options is to recognize that there are many forms of accountability. And by creating policies like this that again center the interests of complainants and survivors, that they can seek the forms of accountability that matter the most to them. And you also talked about screening was another note that I made, but I think that I touched on it in talking about how complainants need to be actively involved in the pre-screening of these kinds of cases for mediation and restorative justice. There is a burgeoning expertise in family law, as you'll know. Recent amendments to the Federal Divorce Act have arguably required pre-screening in cases where there's a history of family violence. In many other provincial jurisdictions, there were already requirements that family lawyers and mediators had to conduct pre-screening processes before implementing mediation in cases where there's a history of family violence or intimate partner violence. So there is an expertise there that I believe can be developed to think about how a pre-screening tool could be written and then hopefully implemented by people on campus who have specialized expertise in this area to determine whether the conditions are met for mediation and restorative justice to be implemented safely and effectively.
Thank you so much. I have to say that this work has made me still very, very committed to legal pluralism still, but it really has been informative to me to think about the necessity for formal rules. If only, so thinking about both the utility of formal policies and legislation as both instrumental, like it gets something specific done, but also symbolic. Like we are making a statement in this fashion because it's important to this community of people. And so that's been, both of those things has been really important. I'm not gonna hog you any further. So I'm gonna ask others if they've got questions. Yeah.
I'll just jump in very briefly before
Sure.
you do that. Something that your comments, very good comments, reminded me of. Talking about this sort of symbolic importance of law and a policy and of recognition by courts and tribunals. I think that this really does harken back to foundational debates in the 80s between CLS scholars and CRT scholars about the symbolic importance of rights claims. I think this is what we're talking about. That I would never advocate, as I said, that consensual dispute resolution and the abandonment of formal law in courts is appropriate. The complete abandonment of rights claims, as Patricia Williams and Kimberly Crenshaw and others said, is a luxury of privileged groups.
Yes, exactly.
White men, heterosexuals, class privileged people who have already achieved the equality that others are seeking.
Right.
So I'm not about to suggest that complainants and survivors and other historically marginalized groups should eschew rights claims. Like they're incredibly powerful in galvanizing people in changing cultural norms through the force of law. I recognize that again, which is why I think it's important that we come up with more hybrid approaches that include both formal and informal options.
Absolutely. Other questions or comments for Daniel? Nandini.
Hello, Daniel. Good to see you. And really happy. No, I'm really happy that finally we could have you under the auspices of the center. And really, really enjoyed your chat. And I really appreciated the insights you have provided. And I have a very specific question, and which pertains to advocacy, the role of advocacy. And I think advocacy, very vocal and powerful advocacy, has what brought this issue to the spotlight and has made institutions respond in a concerted manner. But I would like to ask, and has advocacy is the reason where, does it put pressure on survivors to not seek the alternative justice route or restorative justice route, because there is peer pressure. And this is a time that we need to, accountability has to be established through formal mechanisms. And I'm wondering, particularly in the campus setting, since we are dealing with young individuals and those who are survivors are already vulnerable, do they feel the pressure to not go the alternative route because it'll make them look as making a compromise, being an anti-feminist, and so on and so forth?
It's a great question. The first thing I'll say, just to make sure that all perspectives are represented, is that something that's often told to me, or stories that I hear from complainants and survivors, is that they actually feel pressure in the other direction, that they do feel pressure by campus administrators to engage in informal processes, or simply not to file complaints at all because it would be an incredibly traumatizing experience. So I don't want to suggest that the overwhelming pressure that complainants experience is in fact one to go public and to access the formal law in order to seek change. So just with that on the table, your question was about sort of from an advocacy perspective, from a legal change and social change perspective, whether complainants and survivors may be pressured to use formal mechanisms. And I do think that to an extent that pressure exists. I think that it's more intuitive for people, in a legal culture that is structured by liberal legalism, by legal centralism. As I said, I think that it's often what is seen as the easiest or the natural way, particularly in a law school, to achieve this kind of change through this kind of formal recognition. If only we had a policy, if only we had a better policy, then things will change. I mean, Sarah Ahmed's work tells us very clearly that in fact these policies can be hollow performatives, that in fact it is not through these kinds of formal changes often that we will see meaningful change on the ground. I think it's interesting to think about then consensual dispute resolution, and in particular restorative justice, which I think holds the most potential in this regard, if conducted in a way that addresses campus sexual violence as a systemic problem, how these processes can actually result and provide social change for people. So again, in the Dalhousie case, again, not saying that process wasn't flawed in some ways, but if it is not seen as simply a backdoor meeting between an administrator and a victim, having the victim sign an NDA and then hopefully never raise their concerns publicly, but instead if it's a process which is conducted responsibly, if it leads to tangible outputs, the restorative justice case, not only were there countless stakeholders who were involved in the process, but it resulted in several public reports that people could read. And it also led to concrete changes in the university culture. Committees subsequently, had to consider the findings of the task force and the restorative justice facilitators in various meetings, in various annual reports on equality and that kind of thing. So if these processes are conducted in such a way that builds in these kinds of forward-looking accountability mechanisms, I think that they really can be agents of social change in a very real way. It's just that doing that kind of work is hard. It takes time, it takes expertise. We've talked about expertise in pre-screening. We've talked about expertise in restorative justice facilitation. These aren't easy things. And it takes a lot of money. It takes a lot of resources. Another concern that I get, that I have people tell me all the time, particularly people that have worked in campus administration, is that, oh, well, it sounds great. This model that you proposed sounds great. If only we could implement it. If only it wasn't just me sitting in an office, who's charged with handling sexual violence policies. I would love to do the work that you're doing, but I simply don't have the resources to do that. So I think it's a challenge, and it needs to be tackled, as I say, with targeted action, not only from university administrators, but also from the government, who supports university administrators in doing this kind of work.
Thank you. Yeah, resources are definitely an issue, although there's been a lot put behind this. And I guess one of the things I find really, really interesting, though, just going to Nandini's question, is on the question of the pressure of people to go formal or informal. Is going back to your case study at Dal, the decision whether to participate in that process or not drove a wedge through many women scholars and feminist scholars. Yeah, I won't say more than that, but it's kind of an important thing about, what does it mean to be a bad feminist? And I think that's really unfortunate because it was at cross purposes with the healing that was the objective of that entire process. So I do find that, on these conversations that the divergent perspectives of feminists are not always welcome at the table, and the idea that you could be open to the kinds of processes that you're describing and really standing behind. I'll just say that in some discourses, and I've been in lots of different settings, both in my own role right now, but also in thinking about legislative change around the courts that Penelope was referring to, it is viewed as very antithetical to a feminist objective to think about ADR. And to think about informal resolutions, and to think about the move away from the individual respondent to the structures or the systems, right? So it's sort of the sense is that if we think about this as, yes, there was one form of misconduct by one person, but that's a reflection of rape culture that's across an institution. That is really unsatisfying. And if you go back to the report on Dal, one of the big concerns people had about from my memories, that the restorative justice report, people were frustrated because they said, well, we don't have any visibility into the punishment, right? Like, people not only want the punishment, but they want to know. They want proof of accountability. And it's super interesting because in Quebec, the legislation is changing now so that people who report sexual violence in universities will now have the right to know what the disciplinary outcomes are. And that is viewed as something that is kind of progressive and will lend itself to closure for survivors. And I don't really have a strong opinion on this, but it's a waiver of the privacy regulations in the province for sure. And it's viewed as justified. So fine, but I will bet that there will be much, much anger when the punishment imposed does not reach termination of employment in the case of a staff member or expulsion in the case of a student. And in the cases I see, particularly involving our incoming students, it's definitely clear that our definition of sexual assault or sexual harassment was met, but there is often real confusion in the minds of the individuals concerned. And the kind of state of grace that I think is necessary to move forward as a community, I don't think it exists right now in many post-secondary contexts. And I'm speaking really frankly. So it's really, really a tough context. It's a very kind of unforgiving context where, and that's being kind of framed as a need for accountability. And of course, there needs to be accountability, but if it's framed as, we're going to discipline and impose measures like mentoring and classes around how to think about and understand toxic masculinity, what consent is, right? That's viewed as giving a favor to the respondent, when in fact it's necessary, I would argue.
Mm-hmm. Again, all great points. Something you talked about the Dal case, just to briefly sort of build on what you said about how feminists and many feminist legal professors, even at Dalhousie, were deeply divided and remain divided about this case. And it's symptomatic, I suggest in my book, I talk about this, that these kinds of feminist contestations about dispute resolution are a symptom of what others have called the return of the sex wars. Mm-hmm. That many of these contestations between feminists about the viability, the possibilities of consent, right? About the need to explode the private into the public, whether we're talking about the bedroom or the boardroom, that these are the same kinds of debates that are simply being rehearsed about different issues. So I think it's really interesting, and that's what I really explore in greater depth in the book. This particular talk didn't focus on that aspect, but I find it really fascinating. Something else that I'll say about that process, the Dal process, which I think motivated some of the feminist concerns about the process, and it's something else to put on the table because it's challenging and it makes these issues even more complicated, is that the majority of complainants in that Dal case chose restorative justice. They wished to proceed in that manner. And in response to suggestion that complainants were being pressured to choose that option. They issued public responses saying, no, we weren't pressured. This is something that we wanted for ourselves. I think it was 13 or 14 classmates said this. However, there were 3 or 4 classmates, including the sort of lead complainant who broke the story, who did not want to participate in restorative justice and wished to proceed with a formal process. And this raised challenges because they were then excluded from the restorative justice process. And the perception was that the school was sort of pushing this process. This was the preferred process, and there wasn't a meaningful alternative or parallel option for these other students. So the answer isn't simply, without more, well, run a parallel process for these students, because this raises very challenging questions about parallel proceedings and confidentiality, right? So critics have raised questions in this context. How can the integrity of consensual dispute resolution be maintained if complainants or respondents believe that statements they made in a consensual process could be used against them in a concurrent proceeding, right? So complainants are entitled to know whether they can share their experiences without opening themselves up to a civil claim in defamation, right? A slap suit. We've seen this over and over again. Respondents similarly are entitled to know whether they can share their experiences in restorative justice. As I said, typically it's a precondition to participating that they accept responsibility, right? But how can they do that without fear of providing evidence that could be used against them rather, in a criminal case or a civil case or human rights proceeding, or in a campus adjudicative process spearheaded by other students who are affected by their conduct? So this is a very thorny evidentiary issue that really needs to be addressed, I believe, as part of this move that I think is necessary to provide complainants with a range of options, particularly in cases like Dal, where there may be several complainants who have different interests and wish to proceed differently. And it's not an intractable problem. There are solutions that I suggest we can implement. In some jurisdictions where there are restorative justice processes in place, in the criminal context, for instance, colleges and universities should enter into memoranda of understanding with local police and prosecutors, according to which police and prosecutors agree that any evidence obtained in a consensual process cannot be used against the respondents to support criminal charges. There are other kinds of evidentiary solutions that can be thought up, but this was something that I suggest was not thought of and not implemented sufficiently in the Dal case, which gave rise to a situation where there were a minority of complainants who were, I suggest, disenfranchised effectively, who were not given a meaningful option to proceed. So, granted, this process did a lot of things very well and they did them effectively, and that many complainants, the majority, were satisfied with the outcomes, and many stakeholders were as well, but there were some who would testify very compellingly that this process silenced them.
Yeah, it's really fascinating, and it's such important work, because I think these sorts of things are going to continue into the future, and people don't. They'll think that a process that has either a formal flavor to it embedded in a policy will be an answer, or a restorative process. And I think the case at Dal is a really interesting one for that because of the number of people. It involved a whole class, right? So I think that lent itself well to thinking about that kind of a process. But you're right. I think the people who didn't get or chose not to participate, the evidence from them was pretty clear that although that was their choice, they didn't feel that they had an alternate path, which was a deprivation. Sharon?
I guess my question is a little bit about sometimes, well, in the Dalhousie case, there were many, as we've talked about, there were many people making complaint at one time. But sometimes these patterns emerge over time, and when we know that not everyone comes forward. And so, if we're looking at there was clearly, to some extent, I'm not a professional, I'm not a lawyer, right? But that there was a culture that allowed that to happen. That person who sent that email expected that there were some people in that Facebook group that were going to receive that well. So if we're looking at culture change as the goal, and we know that not everyone comes forward and that patterns emerge over time, and we even have sort of the important person clause where eyewitnesses don't recognize what they're seeing because they see the person involved and know in their minds that person would never do such a thing. And so in terms of the processes, it might I guess I'm sorry if I'm not articulating my question well, but like the balance between formal and informal processes, how do we get most quickly to the tipping point where the culture changes? I don't know if that's a good question.
Mm-hmm.
It's a great question. One that I think Professor Campbell could answer just as well as I could from her experience. I think, again, if at least in the context of consensual processes, if they're implemented in such a way that, you know, the administration ideally is participating in the process and committing to taking action as a result of what the parties decide, if there are community members who perhaps enable the respondent, or if there are third-party community groups who can lend expertise about you know, structural aspects of the learning environment that contribute to violence. And they perhaps also commit to participating in educational initiatives and these kinds of broader cultural changes beyond simply, you know, the respondent, the responsible person receiving education. Then I think that we can think about cultural change. It can sort of be, I think, we can probably learn lessons from work that's been done in the domestic human rights context, where human rights tribunals are empowered to award public interest or systemic remedies that are aimed to achieve this kind of cultural change. So just to think beyond simply two people, a complainant and a respondent, or a survivor and someone who harmed them, and a remedy that is directed at the respondent only, but at broader institutional actors and community actors who have a stake in the issue and who can take positive action to create the change that is necessary on a more structural level.
I might just ask you one more before we leave you. So, which is, is your work thinking about the unique context that a university provides? So, you know, thinking about sexual misconduct generally in organizations, or sexual abuse in schools, for example, or in other institutions where there's very obvious power differentials. One of the things I find really interesting is thinking about the very, very kind of unparalleled context that a university offers for dealing with difficult questions like this one, but also questions of free expression, what kinds of activities are considered to cross the threshold into harm, right? If you think about research activities, for example, and the university is so, and all the universities are not the same, obviously, but they're marked by really explicit hierarchies and by the kind of main feature of the workforce is a group of people who really prioritize their independence and are not like the typical employee in a workforce, and a group of people who are young, but vast majority are of age, right? So they can consent to sexual activity, and where you're dealing with many people being independent for the first time in their lives, right? Without necessarily having the social skills to be equipped for all of that sudden drop of responsibility on the 1st of September when they're 19, you know? So I'm just wondering about thinking about what the university specifically offers you as a site for your work.
It's a great question. So you raised the point, it's a very important one, that particularly university-age students, particularly first-year students that are in orientation these initial months.
Yeah.
Studies actually show that vulnerability to sexual violence is highest when people enter university. And it's for all the reasons that you said. It's that people are of a particular age, they're young, they're away from home for the first time. They often come to see their universities as sort of guardians of their moral development, which then means that when they're often shocked, surprised, hurt by things that have been done to them or been done to their friends, it's a real grievous shock. It causes harm. It causes, you know, what people have called secondary victimization.
Right.
By the fact of a college or university, their college or university failing to respond adequately to the harm that was suffered. So that vulnerability is very important to recognize. Something else that I'll say just about the university context is that I think that there are different concerns that attend to cases involving two students, or cases involving students and professors, or students and employees. And just from a purely legal perspective, I mean, cases involving students and employees and professors are subject not only to sexual violence policies, but conflict of interest policies.
Right.
There's provisions in collective agreements. So it's a much more complicated I suggest sort of legal framework that applies, but also just concerns about power imbalance that I talked about earlier are obviously exacerbated in cases involving students and professors or employees who are already embedded in the institution and have connections and could potentially in some cases wield power over the students' development and grading, et cetera. So those cases, I believe, require more attention. And some of my comments about the availability and the options of consensual dispute resolution, I think should be tempered by that fact. I think that the availability of these processes should be significantly limited in those kinds of cases. The last thing I'll say is that I think, though, there's a real synergy between the educational mandates of colleges and universities and the potential of mediation, and particularly restorative justice, to achieve the kind of cultural change that we were talking about before, right? Because colleges and universities simply don't have the same penological objectives as the state, as the criminal justice system. So as a result, some of the educational remedies that are available in restorative justice, uniquely available in this process, I think fit very well with the mandate of colleges and universities. So I think it's very interesting to think about college and universities from that perspective as laboratories of innovation, right? It's a great place. I think it's a site where we can pilot the use. There have been pilot projects of restorative justice in sexual violence cases around the world, including in Canada, but for someone like me who suggests that these kinds of processes should be researched and expanded, I think that colleges and universities provide an important site for piloting these kinds of processes to really build our evidence base and think about then how we can expand these insights into the legal system more broadly.
Yeah, I totally agree with that. That's great. And the expertise is there too. So, well, first of all, I want to thank Nandini for asking me to moderate today. So thank you for the opportunity. It was so great to hear from you, Daniel, and to meet you. And I'm sure we'll have an opportunity to connect and chat further. But this has been really, really important presentation. Your work is crucial, and the area in question, I will say, is really under theorized and under researched. So there's a lot of people doing their work, kind of feeling their way around in this area, which is so important to the lives of many young people. And they need this kind of work and guidance. So thank you so much for the contribution that your scholarship is making.
Thank you. That's very kind. And again, thank you again to the Center for hosting me. And it was such a pleasure to chat with you all and learn from your excellent questions and comments. So thank you again.